Hello and Namaste. I am Ketan Kank from 192 Consulting. In this video, we are going to take a look at rule number 6 of the Investor Education and Protection Fund Authority rules. In earlier video, we have considered rule 3, but in this video, we are going to take up rule 6 because rule 4 and rule 5 are not really of the investor's operational purposes or utility. So that's why we are not really going to go into those rules. If investors should have any query regarding those rules, they can feel free to ask their queries to us separately. But in this video, we are going to take a look at very important rule which is called as rule 6. The title of the rule is right in front of me and I'll read out it to our audience. The title of the rule says manner of transfer of shares under subsection 6 of section 124 of the fund. See, again and again we are coming to the provisions of section 124. These provisions have been discussed in detail in our earlier videos. Our investors and audience are requested to refer to the earlier videos so that they'll come to know about the provisions of section 124. Now in this video, we are going to take a look at how the rules stipulate that the shares be transferred to the fund. Now, the rule actually contains 11 sub-rules. I am going to read out the rules and then we will see the crux of every sub-rule. Sub-rule number 1 states that the shares shall be credited to demat account of the authority to be opened by the authority for the said purpose within a period of 30 days of such shares becoming due to be transferred to the fund. Now, the shares are to be transferred. They are to be transferred to the demat account and that is to be opened within the 30 days of the due date when the shares become due for the transfer. Sub-rule 1 further states that provided that in case the beneficial owner has encashed any dividend warrant or any dividend amount has been credited to the bank account of the owner of such shares during the last 7 years, such shares shall not be required to be transferred to the fund even though some dividend warrants may have not been encashed. See, this is again a very interesting provision. The provisions of section 124 states that if the dividend remains unclaimed for 7 consecutive years. Now that the word consecutive has been used in that provision. Here it has been clarified that within that time span of 7 years, if a dividend for particular year has been encashed or claimed, then the word consecutive becomes redundant. It does not become applicable. And if that word consecutive fails to become operational, then the shares should not be credited to the Investor Education and Protection Fund Authority. What happens about the shares wherein the dividends have not been claimed for suppose 6 years and in the 7 years the investor encashes that check or the dividend is being claimed, then maybe the shares are lying with the suspense escrow demat account of the company. But again, that is not the topic of today's video. So in case, the proviso of sub-rule is very important. The shares as per sub-rule 1, the shares shall be transferred to the demat account of the authority within 30 days of becoming due. And if the dividend has been encashed within a period of 7 years, then the shares shall not be transferred. Now, let us see what sub-rule 1 has to say further. Now, the second proviso of the said sub-rule 1 states that provided further that in case where the period of 7 years provided under subsection 5 of section 124 has been completed or being completed during the period from September 2016 to 31st October 2017, the due date of the transfer of such shares shall be deemed to be as 31st October 2017. So this is a specific time frame because as I have told you, the amendment has come in 2015. This is a specific time frame that the companies or the rules have stipulated. Provided further that the transfer of shares of the company to the fund shall be deemed to be transmission of shares and procedure to be followed for a transmission of shares shall be followed by the companies while transferring shares to the fund. Now this deals with the transfer and transmission. These are more complex legalities, those are involved, but for the normal understanding, once the shares are transferred, the time frame of 7 consecutive years is very important for sub-rule 1 to apply. Sub-rule 2, now what does sub-rule 2 says? For the purpose of effecting transfer of shares, the board shall authorize the company secretary or any other person to sign the necessary documents. Now herein, the board is not the Securities and Exchange Board of India. This is the board of directors of the company, who shall actually assign or who shall authorize the company secretary or the nodal officer. See, we have understood the concept of nodal officer in one of our previous videos. The shareholders will have to deal with the nodal officer of the company, because unless and until that nodal officer issues the entitlement letter or that nodal officer verifies the entire documentation of a particular claim, he is not going to credit the shares or process the claim further. So he is being authorized by the board, and that board should authorize that person, that should authorize the company secretary, is laid down under sub-rule 2 of rule 6. Proceeding with sub-rule 3, what does it state? Sub-rule 3 states that the company shall follow the following procedure while transferring the shares. Now I'll read out the procedure, and if the investors have any questions regarding this, they can get back to us. Otherwise, I'll read out the procedure and we'll proceed. Now, clause A of sub-rule 3. What does it state? The company shall inform at the latest available address the shareholders concerned regarding transfer of shares 3 months before the due date of the transfer of shares, and also simultaneously publish a notice in the leading newspaper in English and regional language having wide circulation, informing the concerned that the names of such shareholders and their folio numbers or DPID, client ID are available on their website, duly mentioning the website address. So the company should inform the shareholders, and it should also publish a newspaper advertisement 3 months before the due date. In case where there is a specific order of the court or tribunal or statutory authority restraining any transfer of shares and payment of dividends, or where such shares are pledged or hypothecated under the provisions of Depositories Act 1996, or shares already have been transferred under sub-rule above, the company shall not transfer such shares to the fund. So this is a restraining provision. If there is an order of any judicial or quasi-judicial body against the company for transferring the shares, those shares should not be transferred. C. For the purpose of effecting the transfer, where the shares are dealt with in depository, the company shall inform the depository by way of corporate action where the shareholders have their accounts for a transfer in favor of the authority. So, as by the virtue of Depositories Act 1996, entire dealings or entire investments in shares and securities are done in electronic format through depositories. So the company shall also inform the DPs, the depository participants. Now, what is depository participants? We have taken a look in the earlier video. So next, for the purpose of effecting the transfer, shares are held in physical form, the company secretary or the person authorized the board shall make an application on behalf of the concerned shareholders to the company for issue of the new share certificates. On receipt of the application under clause A, new share certificate for each such shareholder shall be issued, and it shall be stated on the face of the certificate that issued in lieu of new share certificates. Particulars of every share certificate shall be in prescribed from SH1, and after issue of new share certificates, the company shall inform the depository by way of corporate action to convert the shares into demat. So even if the shares are held in the physical form, the procedure for duplicate share certificates have to be done, and then once the procedure is completed, the company will convert the shares into dematerialized form, and those shares will be credited to the demat account of the security holder. Now, this was about Rule 3, for wherein the procedure to transfer the shares to the fund. What does Sub-Rule 4 states? Sub-Rule 4 states that the company shall make such transfers through corporate action and shall preserve the copies of its records. So, it is mandatory for the company to preserve the copies of such records. While effecting such transfer, Sub-Rule 5. While effecting such transfer, the company shall send a statement to the authority in IEPF 4 within 30 days of the corporate action taken under clause C of sub-rule 3 of rule 6 containing details of such transfer, and the company shall also attach a copy of public notice published under clause A sub-rule 3 of rule 6 of IEPF 4. Now, once the shares have been transferred, it is mandatory for the company to inform all these things through a prescribed from IEPF 4 to the authority. Authority is IEPFA, Investor Education and Protection Fund Authority. So, it has to give all the details of this compliance to the authority by way of form IEPF 4. The voting rights on shares transferred to IPF shall remain frozen until the rightful owner claims the shares. Now, see, the shares have been transferred to IPF. The rules specifically say that the voting rights, so the shareholders are not eligible to vote on the shares which have been transferred to IPF. Rule number 7. The company shall maintain all such statements filed under sub-rule 5 in the same format along with the supporting documents, and the authority shall have the powers to inspect such records. So company shall preserve those records and authority shall have the powers to inspect those records. That is laid down in sub-rule 7. What does sub 8 says? It says all the benefits accruing on such shares like bonus shares, split, consolidation, fraction shares and the like, except rights issue, shall be credited to such a demat account by the company, which shall send a statement to the authority in IEPF 4 within 30 days of the corporate action containing details of the shares. Now, if any corporate benefit has accrued on it except the rights issue, the accruing corporate benefits will also go to the IEPF fund or that the Investor Education and Protection Fund except for the rights issue. Rights issue, as I've already mentioned in this video also I'm repeating, but I've already mentioned in the earlier videos, rights issue have been expressly excluded from the purview of these provisions. 9. Sub-rule 9. The shares held in demat account shall not be transferred or dealt with any manner whatsoever except for the purposes of transferring the shares back to the claimant as and when he approaches the authority or in accordance with sub-rule 10, 11 and 11A. The authority is the custodian of the shares. It is being specifically and expressly restrained from not transferring those shares apart from the transfer or refunding or the transfer to the rightful claimant of those shares who is reclaiming them. That is laid down in sub-rule 9. Sub-rule 10. If the company is getting delisted, the authority shall surrender shares on behalf of the shareholders in accordance with the SEBI Rules 2009 and proceed realized shall be credited to the fund and a separate ledger account shall be maintained. So this is this deals with the company, a listed company getting delisted. Sub-rule 11. In case the company whose shares or securities are held by the authority is being wound up, the authority may surrender the securities to receive the amount entitled on the behalf of the security and credit the amount to the fund, and a separate ledger shall be maintained for such proceeds. So sub-rule 10 dealt with delisting. Sub-rule 11 is dealing with the winding up of the company. Sub-rule 11A, that is the last sub-rule of rule 6, it deals with in case the application for the purchase of shares under section 236 is received through the company, the authority may receive the amount entitled on behalf of the minority shareholders from the company as per proceedings provided under subsection 5 of the said section 236 and credit the amount to the fund, and a separate ledger account shall be maintained for such proceeds, provided that the authority before such receipt of money on behalf of such shareholders shall verify the conditions provided under the relevant section of the Act and rules framed thereunder has been satisfied, and shall also call a report from the company on the following. And it lays down on what counts the report has to be taken. So this was rule 6, which dealt with the transfer of the shares to the Investor Education and Protection Fund. Should you have any query relating to the shares or reclaiming of the shares, securities and investment from Investor Education and Protection Fund Authority, you may please feel free to call us, to reach out to us, or you can reach out to us by simply marking your comment in the comment section of this video, or you may write to us on info@NineteenTwo.in. We will be all the more happy to help. Till the time, this is Ketan Kank signing off. Thank you so much.